Any lawyer will tell you that it's very important to define your issues before you go into argument and or to resolve a legal case. And in this connection, I think it's very important to take a look at how the Turks apparently define the issue in the Aegean. In the June 1996 issue of the Fordham International Law Journal, the Turkish ambassador to the United States, Kandemir, said that the tensions in the Aegean are the result of a clash of civilizations, kind of piggybacking on the theme of Professor Sam Huntington of NYU, who views the world going through this period of clash of civilizations. And he said that Orthodox Christian civilization is seeking to settle scores with the old Ottoman Empire using the current Republic of Turkey as a foil. In this similar theme, just a few days ago, former Prime Minister of Turkey, Bülent Ecevit, made the statement that Turkey is surrounded by an Orthodox siege that starts in Serbia, goes through Greece, Russia, the Caucasus, and ends in South Cyprus. This is how they define the issue in the Aegean. I submit to you that both are seriously diluted. That is not the issue at all in the Aegean. The issue in the Aegean is Turkish challenges to Greek sovereignty, legal sovereignty, established by treaty over the Aegean Islands. I'm going to only discuss the Aegean Islands. The territorial waters, continental shelf, and airspace are equally important, but time doesn't permit that. By the Aegean, I'm talking about all islands, big, small, or indifferent, in the Aegean. Turkish challenges have taken the form of a statement by current Foreign Minister Tansu Çiller, that Turkey is reviewing the legal status of all 3,000 Aegean islands. We have Imia as an example of this review. Gavdos, a challenge to Gavdos, a small island off the southern coast of Crete. Challenged, the sovereignty challenged. Let's talk about territorial sovereignty and what it means. In brass tacks, territorial sovereignty is very similar to your ownership of your property, whether it's a house or a commercial property. You have that by virtue of a legal instrument, normally called a deed. Greece's sovereignty to the Aegean Islands is established by the result of two legal instruments called treaties. We have to discuss the two groups of islands, the Northern Islands and the Dodekanes, separately, because they're really under two separate legal treaty regimes. Between 1878 and 1913, Greece seized the islands of Limnos, Lesbos, Chios, Samos, and Ikaria from the declining Ottoman Empire through a series of military actions. And the actions were premised primarily on the fact that there were substantial or majority Greek populations on those islands. Now, after 1913, Greece exercised de facto control over these islands, but did not have legal title to these islands. The Treaty of Lausanne of 1923, that ended World War I in the East, provided Greece with the legal title to those islands. It also set the border between Greece and Turkey in the land border in the north. With respect to the Dodekanes, however, Greece never exercised de facto control or sovereignty over the Dodekanes. The Treaty of Lausanne, instead of granting sovereignty, as it should have, to Greece, granted sovereignty to Italy. The U.S. Senate at that time passed a resolution calling on the peace conference to award the Dodekanes to Greece. But as a result, Italy received the Dodekanes Islands in the Treaty of Lausanne in 1923. They remained under Italian sovereignty until the Treaty of Paris of 1947 that ended World War II against Italy, and in that treaty, the Dodekanes were then ceded to Greece. Consequently, Greece's title to the Aegean Islands is a result of treaty, an agreement amongst equally situated partners. Let's look at the basic Turkish position as we understand it, and bear in mind this position is what we've gleaned from official statements, writings. There's been no court action or anything of that sort. But the basic Turkish position appears to be that any island or islet that is within 6 miles of the Turkish coast, I'm not sure whether that means the coast or any Turkish islands just beyond the coast, which is not an island expressly named in either the Treaty of Lausanne of 1923 or the Treaty of Paris of 1947, that the Republic of Turkey has sovereignty either because it remained with Turkey or reverted back to Turkey as a result of these islands not being named in the treaties. Now let's look at each of the island groups separately, and we'll see how this legal challenge is simply wrong. Recall that the Treaty of Lausanne now confirmed Greek sovereignty over the northern islands. When it came time to decide which islands, the smaller islands that surround the bigger islands, were to remain under Turkish sovereignty, the drafters of the Treaty of Lausanne simply looked at the situation and said, well, look, how does it stand right now? That's where we're going to draw the border. Consequently, rather than drawing a geometric border, the drafters simply said that any island that was less than 3 miles from the Asiatic coast, meaning the Anatolian Greek coast, are Turkish. Anything beyond that 3-mile limit are Greek. Consequently, the Turkish 6-mile claim contravenes the treaty. It is against the law. It fails. The Dodekanes situation is a little more complicated. Greece never exercised sovereignty over the Dodekanes. When Greece was granted sovereignty in the Treaty of Paris in 1947, it received only those territorial rights that Italy had that Italy received in the Treaty of Lausanne. The IMIA crisis of January 1996 aptly demonstrates the legal issue involved here. When Italy received the Dodekanes Islands in 1923, there was a controversy that was not resolved, and that was the island of Castellorizion, which comes around almost to the southern coast of Turkey. The precise border there was not defined. In the years following 1923, Italy and Turkey went through a series of negotiations that failed. They even took the case finally to the Permanent International Court in 1928 and submitted it to the court to resolve. But before the court ruled on it, Italy and Turkey entered into an agreement that settled the issue, and they moved the case from the court. And they came up with a convention that drew the line between Castellorizion and the Turkish coast, and designated which islands fall within the Turkish side, which in the Greek side. That was in January of 1932. Later on that year, although this was not in dispute, the parties said, well, if we're going to draw a line around Castellorizion, we better do the same thing along the line of the rest of the Dodekanes Islands, and they did that. And that culminated in a protocol in December of 1932 that drew a geometric border, and it describes in very precise detail where the line runs. It is clear that from that protocol that IMIA falls on the Greek side. There's no question about that. Well, so what then becomes the legal issue in the Dodekanes? Well, Turkey claims that because the protocol that drew this line with IMIA on one side and the Turkish islands on the other side was not registered with the League of Nations, it's not binding. That's a red herring legal position. It has no force. It was very clear at the time that Article 18 of the League of Nations that specified non-registered treaties would not be binding was very controversial. There are any number of theories on which this position fails. Most importantly, if it is passed now, that border has passed into customary international law as a result of it having been recognized by every nation in the world, including Turkey and Greece, for 60-some odd years now. The second challenge is, well, forget registration. When the Treaty of Paris in 1947 was signed, it superseded this protocol that drew the line between the Greek islands and the Turkish islands. And so therefore, those islands, IMIA, they all revert back to Turkish sovereignty. There again, that position is meaningless. There's a very established principle in international law says that if a subsequent treaty supersedes a prior treaty, it must specify that in the treaty. The Treaty of Paris says nothing. Greece received whatever Italy had. Italy had the IMIA, the border that was drawn by the protocols, and the border that was drawn around Castellorizion. There simply is no question there.